So will Mr. Zavaleta and Mr. Villalobos please come on up? Thank you, gentlemen. We'll get, as I said a few minutes ago, we'll start off with an opening statement by both candidates. And I'll start on my left with Mr. Zavaleta. He'll be allowed, let's see, what do we have here? He'll be allowed 3 minutes. 3 minutes for Mr. Zavaleta.
Good evening, ladies and gentlemen, and thank you for coming tonight to the South Texas for Good Government Candidate Forum. First of all, I want to salute the membership and the leadership of this organization, and thank you for holding elected officials like myself accountable over the years. I ask that you continue to do that. I support fully your mission and applaud you for your efforts, and thank you to all of you that have come tonight to hear from the two candidates for the position of District Attorney. In this brief opening statement, let me just give you 3 reasons why I believe, with all due respect to the incumbent, that I am the better choice to serve as your district attorney. First, I am an effective lawyer. Second, I am a proven leader. And thirdly, I am a trusted public servant. I'm an effective lawyer, ladies and gentlemen. I have twice the years of experience as a lawyer that my opponent had in 2004 when he ran for district attorney. I've been a lawyer for 21 years and licensed to practice in all courts throughout the state of Texas, as well as the Supreme Court of Texas. That is almost twice the amount of experience that Mr. Villalobos had when he came before you back in 2004. Secondly, I want to talk to you about a directory called Martindale-Hubbell. Martindale-Hubbell is a directory of lawyers assembled nationwide, and it's basically a rating system that is used by lawyers to rate ourselves. Every year, 3 or 4 times a year, every year, lawyers get questionnaires asking us to rate our colleagues on 2 criteria, legal skill and legal ethics. And it's designed to be confidential so that we can rate our colleagues fairly and appropriately. And every year that my colleagues have rated me on legal skill, my legal skill has always been rated high to very high. And I'm proud of that rating. And I'm proud of the 21 years that I've had that rating. However, on legal ethics, you either get high ethics or nothing at all. And every year my colleagues have rated me, in the 21 years that I've been practicing law, the highest legal ethics that any lawyer can have. No lawyer in this country can have a higher legal ethical rating than I have. By contrast, even though Mr. Villalobos is eligible to be rated by this service, he has never received a rating for either his skill or his ethics. Now, these are peer-based ratings. They're from judges and lawyers, and I stand before you as the only lawyer in this race who has a high to very high legal skill rating and the highest legal ethics that any lawyer can have. I will not have time to get to the rest of my qualifications. I will save that for later. I am a proven leader, ladies and gentlemen. I have been called on by my peers in all places throughout my life, in my church, in my community, in civic organizations, to lead them. I have been an effective leader. I have also been a trusted public servant. Thank you very much.
Good evening. Thank you once again for having me here. I've come and appeared before you guys several times. You have a much bigger crowd today, so that's a good thing. I do want to talk about experience as well. This office as district attorney is a very, very important office for the public. It's the chief law enforcement officer. You do have a sheriff who's also a chief law enforcement officer, but the DA has to have the cases that come in from every legal, police department, DEA, FBI, anybody you can think of. All the cases are going to be funneled for the DA's office when you're dealing with criminal cases. You have to have the right type of experience in order to be the DA. When I started out 10 years ago working in criminal cases, I was fortunate enough to go work in the DA's office. I worked under 2 different DAs. I worked under Mr. Reese Sines and under Ms. Yolanda De Leon. I worked my way from the bottom. I worked my way from juvenile cases, from drug cases, from forfeiture cases, dealing with felony cases. I completed the gamut. That type of experience you have to have doing the cases in the courtroom, doing the cases in the district attorney's office, not coming forth later in life and saying, I can handle it, just give me a book and let me read it. This is the type of experience that you need to put somebody in there that can answer the calls from the PD when they call you at 2 o'clock in the morning and ask you, what do I do with the suspect? How do I get the search warrant? I can answer those calls. I have answered those calls. You have to have a DA that can walk into the courtroom, face down that defense attorney, face down the defendant, and try the case himself. I can do that. I have done that. You need a DA that can go in there and you can make a judgment call, make an argument with the judge, and the judge can respect you. I have that respect, and I've done it before the court. You don't need a DA that's going to be on-the-job training, learning the craft as you go along. We had that before. 4 years ago, the big issue was, do you want a hands-off attorney or a hands-on attorney? We had terrible turnover. We had cases that were being lost that shouldn't have been lost. You had police officers that were getting frustrated because the DA's office was not supporting them. We changed that. We have fulfilled our mission from 4 years ago, and it's only been 3 years. I got elected 4 years ago, but I took office 3 years ago. We have fulfilled those promises we made. You see me in the courtroom trying those cases. You see me leading the troops. We do not have turnover, and we win more than 99% of our cases. We have fulfilled our pledge, and we're going to continue to do the job and do it correctly. Thank you.
We have 7 or 8 questions that will be the same for each candidate. And then we have 2 specific questions that we felt were weighted equally for each candidate. We'll get to that later. So we'll start off real easy. And we'll ask Mr. Zavaleta, who's top 5 financial supporters, our question number 2. We have 1 minute.
Well, as my wife will tell you, I am my #1 financial supporter. I've loaned my campaign $9,100. My father, Dr. Zavaleta, and thank you all the way, by the way, for the prayers that you're offering up for his recovery, has also donated $5,000 to my campaign. Relatives of Mark Yates have donated $5,000 also to my campaign. But that's not the entire story. We continue to raise money throughout Cameron County from people who will probably never have any direct dealings with the district attorney's office. People who have who probably never stepped into our office there at the courthouse. But people that see that there is a serious problem of too much politics and not enough justice at the district attorney's office. They're taking ownership of the situation. It is their county as much as it is mine, and they are opening up their checkbook and supporting my campaign, and for that I'm deeply grateful. I'm also grateful to the number of volunteers that have opened up their homes for coffees or hosting parties for me throughout this county. Thank you very much.
In addition, I've loaned myself $10,000, so I think I got beat by $900. But as far as campaign contributions, we get them from all walks of life. We have them from doctors, lawyers, and business people. There's been much to do about the lawyers donating money to me. They're the ones that have the financial ability to fund a campaign. If you look at all the people that run for office in our particular field, whether it's DAs or whether it's judges, they have to go to lawyers. Now, the lawyers are not going to support you if you don't know what you're doing. The lawyers aren't going to support you with their money if they feel that you're not doing a good job. If you look at our campaign finance report, the lawyers that have donated money, most of them have gone to trial probably against me, and I've beat them. So they respect what we do there. They give us their hard-earned money, as well as the doctors, as well as the business people in the community. So it's a widespread support. It's a system that we have to have, and if they do away with the system where we can all run for free, I'm the first one that will sign up.
The next question will be question number 1, gentlemen. and that's a 1-minute response. And I'll start off with Mr. Villalobos, and that is, please explain your philosophy and position on the death penalty.
I am for the death penalty. I've been for the death penalty since I've been an attorney. I have worked as an assistant DA, I've worked on capital cases, and now as district attorney. We have tried cases and enforced the death penalty. We have one coming up, the Rubio case that everybody's familiar with. That is one that we're going to try for death completely. Now, there is a debate in the Supreme Court right now, as we speak, as to whether or not they're going to outlaw the death penalty, but it's only as to method, not the sentence itself. So we feel that we continue to try these cases for the death penalty, continue to get verdicts of death penalty, and that these sentences will be carried out. We have about 10 death penalty cases eligible per year. Out of those, we normally will only try 1 or 2 that are death penalty eligible because of the cost to you, the citizens of the county. But as far as whether I'm for it or not, I am.
As a young college student at UT Austin, I was against the death penalty on religious grounds, and I always felt that it is constitutional, meaning that the cruel and unusual punishment clause does not prohibit a state from imposing the death penalty for capital offenses. I believe that Emmett Livingston deserved the death penalty, ladies and gentlemen. He shot his victim with a .40 caliber weapon at point-blank range in the back of his head. Instead, the current district attorney gave him 23 years and a 60-day head start. Emmett Livingston should have been put to death. Let's not talk in theory, let's talk in practice. That is a man who murdered in cold blood and is at large because the district attorney failed to object to his defense lawyer's request to be given a 60-day head start on law enforcement. Emmett Livingston should have been given the death penalty. I fully support it.
A rejoinder here because the rules I feel have been violated, so Mr. Villalobos will be able to make a quick rejoinder to the statement that Mr. Zaletta just made, and there will not be a rebuttal. Mr. Villalobos. 30 seconds.
Well, the first point is obviously he does know the law because Mr. Livingston was not eligible for the death penalty, so that right there would be a legal sentence. Second of all, I did not agree to allow Mr. Livingston to go free. Mr. Zaletta should know that when we deal with these kind of cases, you go back, you talk to the judge or the defense counsel, the judge is going to tell you what's going to happen. Mr. Livingston was on a bond, he was free to leave, there was nothing the state could do about it. The judges do not listen to us all the time. We make an argument, the defense makes an argument, and the judge decides what happens to defendants like Mr. Livingston.
We have some extra seats up front. If anyone would like to sit down, please come on up front. We do have some empty seats. Our next question will be question number 3, gentlemen. And that's a 1.5 minute answer that we're going to give you. And we'll start with Mr. Villalobos. And that will be discuss your philosophy in regards to plea bargain agreements. Mr. Villalobos.
Plea bargains are extremely necessary in our business. We deal with 16,000 new cases a year. The courts, unfortunately, do not process 16,000 cases a year. They only process about 10 or 11. So that leaves a carryover 5,000 cases a year that we have to add every single year. So you go back over 10, 20 years, that's a lot of cases that our office has to deal with. Plea bargains are only going to work, though, if the DA is strong enough to enforce them. What I mean by that is a defense attorney or a defendant is not going to walk into the courtroom and say, I did it, if they know that the DA can't back up the case. When you look at a case, think about it realistically, think about it logically. They're going to plead when they know the DA can back it up. We can back up our trials when we go into court. We can back up what we say. So because of that, we have a pretty high rate of people that plead guilty and accept their punishment. The other thing that's important to remember is that when you go before the judge on the plea bargain, the judge determines what the sentence is going to be. You can tell the judge, I recommend this person get probation, I recommend this person get 50 years, 40 years, 30 years, and the judge can tell you, I agree, I disagree, I'm going to give him or her what I want to do. So the plea bargains are not all that they're cut out to be. And if you want to say that it's up to the DA to determine what every defendant's going to get, then you might as well do away with the adversarial process, and you might as well do away with the defense attorney. That's not how it works. If it were up to me, we wouldn't need a court, and I would determine what everybody gets, but that's not how it works.
Thank you. I think plea bargains are important. They're a necessary evil, but we should always keep in mind that there should be two objectives to every plea bargain made in every case. To not only punish the accused in that case, but to do something to deter him or her from committing a crime in the future. And this is a great failing of the current administration because, let me take burglary for example. The Brownsville Herald just reported this week something that I have learned from personal experience, having been burglarized 3 times, twice at my office and once in my car in the last 18 months. I've learned this firsthand and also from chiefs of police throughout the county that burglary is a terrible problem and is only getting worse. In the last 4 years, it has gotten worse. And I believe that one of the reasons that the problem is getting worse is because the current district attorney does not insist on appropriate restitution, which means paying the money back from people that steal. When I am elected district attorney, we will not offer plea bargains to any crook who does not pay the property owner at least the deductible on the homeowner's insurance or at least the property value of what was stolen. I want the message to go out loud and clear that crime does not pay in Cameron County. If you steal, you will repay. If you don't have the money, you will be put in jail. That will not only tell that crook that it doesn't make sense to steal again, but he will go back and tell the little small network of crooks that steal and steal again, look, in Cameron County, no nos conviene, okay? It doesn't work in Cameron County anymore. There's a tough guy there at the DA's office. He will make sure that you pay back the restitution if you even think about probation. Thank you.
Quickly, once again, it's not up to the DA on the restitution. We make a recommendation, the restitution, it's up to the court to order it, it's up to the court to enforce it. That is one of the differences of advocating here, that I know the criminal laws.
No, sir. Our next question will be question 5 on your list. And we'll start off with Mr. Zavaleta, and that is, let me read question. Do you use or condone the use of paid political operatives, in your campaign, and what is, in your opinion, of their use? And that includes gas money.
Could you repeat the question, please?
The question is, do you use or condone the use of paid political operatives, politiqueras, in your campaign? And what is your opinion of their use? Mr. Zavaleta.
Thank you, Mr. Jones. I am not using them, so I believe my opponent must be, because they're not in my office. And they're not being paid at my office, and we're not using them in our campaign. Mail ballot fraud is a big problem in Cameron County, but in the last 3 years, Mr. Villalobos has not prosecuted a single person for this offense. I don't expect that to change anytime soon. And it will certainly change once I am elected. I am proud to say that I was the first one in this race to publicly state in a press release disseminated to the print and television media that we will not use politiqueras, that it is a blight on the men and women who are fighting overseas to protect our right to vote, that people would prey on the elderly and the vulnerable to get their vote for a silver dollar or a sum of money. It is against the law. They should be prosecuted. Unfortunately, they have not been in the last 3 years. I am not using politiqueras. I will not use politiqueras. We will win this election, ladies and gentlemen, by real votes from real people casting real ballots on election day. Thank you very much.
again, I would have to disagree. What you have to do is go out to some of these corners and see the people that are holding Mr. Zavaleta signs, and they're obvious politiqueros. I mean, everybody knows that. You can look on the websites and you can see pictures of obvious politiqueros holding the signs. So I would disagree with that. We don't condone the use of politiqueros. In order to get a case prosecuted, and I will have to explain the law one more time again, is you first need evidence and you first need a case file submitted to us. We don't prosecute people out of thin air. And if he wants us to do that, we're not going to do that. You have to have a solid case turned into us, and we have to prove it beyond a reasonable doubt. You bring me a case like that, I guarantee you I'll get a conviction. Thank you.
The next question will be question number 4 on your list, gentlemen, and that's 2.5 minutes. Let's make it 2 minutes and 45 seconds. The question is, and we'll start with Mr. Villalobos first this time. The question is, discuss your grand jury philosophy in regards to its formation, usage, jury authority, and accused participation in jury investigations and deliberations. Mr. Villalobos.
We deal with 4 grand juries every month. We also call for special grand juries. The grand jury process is the backbone of our criminal justice system. Grand jurors have to agree that there's probable cause in order for a case to go forward. But that's the important thing here. All they have to believe in is probable cause. So what we do as prosecutors, when we go in there, we discuss the facts to prove probable cause. The grand jurors at that point will decide on their own whether or not we've met that burden, and if we have, a true bill it. At that point, we still have to go to a normal court, prove it to either a judge or a jury that it was done beyond a reasonable doubt. 2 different standards. Our philosophy is that it's a great system and it works. Our philosophy is also that it works properly without interfered with by defendants' attorneys, or witnesses that are out there rogue on their own. We had several instances where people try to interfere with the grand jury's process, and that's not a proper way of doing it. If you look at the penal code, the proper way of doing it is sending it to the district attorney's office and letting them proceed with it with the grand jury. As far as our philosophy, I think it's a great system. I think it works. I think it works to a great degree because it's a sounding board. There are several cases that we present to the grand jury that they don't feel that we may have probable cause, but they as a grand jury, as citizens of the community, feel like that's not a case that maybe should be prosecuted, and they'll no-bill it. So at that point, we take the grand jury's word and we consider the case closed. Like I said, we deal with thousands of cases with the grand jury. Every case, we give it due time. We have, I would say, 5,000 cases a year with the felonies, where they can come in, we can present the evidence, they can review the case, they can deliberate, they can ask more questions. You've heard the term runaway grand jury or a rogue grand jury. That doesn't really mean anything other than the grand jury does have the power to investigate cases on their own. You might see that when you read the paper in Willis County, where you have people that start investigating each other. I believe that's a breakdown in the system, because at that point, you have everybody a free-for-all. And in order for the grand jury system to work, you have to have teamwork, you have to have them working with the district attorney's office, and you have to have the district attorney's office working with the grand jury. Thank you.
As your district attorney, I will make liberal use of grand juries, not just to indict, but also to no-bill. I think a no-bill is a very important function of a grand jury where people perhaps might suspect that a crime has been committed. A function of a grand jury is to hear the evidence, and if the grand jury decides that there is insufficient evidence to indict and convict, then the grand jury should issue a no-bill. And this reminds me of how the grand jury has not been properly handled with respect to the Brownsville Navigation District. You will recall, as the Brownsville Herald reported on March 9th of 2007, after 2 years of having the work product of our special counsel, Mr. Villalobos announced in the Brownsville Herald that there was not even sufficient cause to subpoena a single witness or even call a grand jury to investigate the theft of $21 million on a non-existent bridge. My reaction was the same as yours. You've got to be kidding me. Not even sufficient cause to call a grand jury. And that prompted Judge Costos to send a letter to Mr. Villalobos that was reported also in the March 9, 2007 Brownsville Herald article. And let me quote part of Judge Costos' letter to Mr. Villalobos. Quote, "There may be an appearance of bias in the investigation process, and although I may not be familiar with all the details of the case, a perception exists that not enough is or has been done to resolve the many unanswered questions that still exist in the public's mind." After throwing a tantrum in the press over whether or not Judge Costos had invaded the district attorney's authority, 2 days later, Mr. Villalobos announced that he would call a grand jury. He announced in May that he would call a grand jury to look into the Brownsville Navigation District. He said the term of that grand jury would end in November of 2007, and he said, quote, "It is our intention to have an answer within this grand jury term." Mr. Villalobos, indict or no bill. Indict or no bill. But this drip, drip, nothing's happening, nothing's been reported because it's an election season, is not working. We need to know the truth. Do you believe that crimes were committed at the Brownsville Navigation District or not? Have the courage of your convictions to indict or no bill. A grand jury is an important tool, ladies and gentlemen. It is a crime in and of itself to give false testimony before the grand jury. Mr. Villalobos, has Lewis Jones been brought before the grand jury? Mr. Villalobos, has James Dannenbaum been brought before the grand jury? Mr. Villalobos, have other people who are directly connected, no matter what title they hold, no matter where they office or what their zip code is, have these people who have firsthand knowledge of what happened to your money and to mine that we will be paying for until 2023, have they been brought before the grand jury? Will you indict or will you no bill? It's very simple. November 2007 has already come and gone. There is no answer from the grand jury. It's time to answer these questions. Thank you.
Again, after a candidate has answered a question, if the following candidate brings him up what might be interpreted as an attack, he is allowed a fairly short rejoinder. In this instance, I guess 30 seconds will be enough. Mr. Villalobos.
Once again, I have to remind Mr. Zavaleta of the law. He's trying to get me to talk about grand jury proceedings, and he knows that that's not allowable. If he would look at the court's records, he would see that the grand jury term has been extended, so we are still within the grand jury term. Additionally, Mr. Zavaleta himself in 2004, when he took office at the court, himself said they wanted to handle it civilly. They handled it civilly. It was a disaster. Why don't you hold him accountable for what he's done? We've had the case since May of 2007, a case that they handed to us with absolutely nothing. We've had to reconstruct that case from the very, very beginning. We're doing that. We're doing our job. But I can't comment as to what exactly is going on in the grand jury.
Thank you. We'll move to page 2, gentlemen. I think this is the right time to do it. And these are specific questions. And we'll start off with Mr. Villalobos. And let me read the question. This is specific to him, and I will have a question that's specific to Mr. Zavaleta. So since we're on the topic, I'll read the question. D.A. Villalobos. Recently, I met Livingston, and both of these questions may not be worded correctly, and I'm sure that I'll be corrected in your answers. So I apologize in advance. Recently, Emmett Livingston was convicted of murder and sentenced to 23 years in prison. Prior to his conviction, he had been freed on $500,000 cash bond. Upon his conviction and on the day of his sentencing, he was allowed to remain free for 60 days in which to get his affairs in order. The following day, his cash bond was attached as part of a civil settlement, and the monies distributed to the victim's family and their lawyer. Mr. Livingston did not return and is a fugitive from justice. Several questions. A. Did the prosecution object to his requested release from custody for an additional 60 days, and why? B. Did the prosecution not know that the $500,000 cash bond was about to be attached by a civil settlement? And C. Why was a larger additional bond not requested now that Mr. Livingston was a convicted felon in order to better guarantee the return of Mr. Livingston and indemnify the state and county in case of his flight. Mr. Villalobos.
Obviously, the Emmett Livingston case has been pretty controversial. That case, our office did a tremendous job on that case. We had a very, very difficult case to prove. One that had all sorts of theories, wild defenses. In our case, our office did its job and produced enough evidence and produced enough against the defense that they took a plea bargain and pled guilty to murder. We fought the bond when Emmett was arrested the first time. When he was first arrested and brought down from Corpus, we asked for and received a large bond from the magistrate court. His attorneys that came in, he's had 3 sets of attorneys, came in and got the bond reduced. They're entitled to do that. Anybody who's charged with a crime except for a capital murder is entitled to a bond. There's nothing the state can do about that. The bond is only good until they're sentenced. Once a person is sentenced, that bond goes back to the defendant if they put up a cash bond, or the surety is off the hook. In this particular case, Mr. Livingston was going to get the money back. The family of the victim filed a lawsuit in the middle of our case. It wasn't done rapidly in succession. They filed it at the very beginning of the case. They had their judgment ready. They were going to attack Mr. Livingston and get whatever assets they could from him for his family. Once again, when we got our conviction, it's up to the judge to determine, number one, if he's going to take the plea bargain, and number two, when he's going to execute that particular sentence. The court knew exactly what our feelings were, because we fought every single time he showed up to court to have his bond raised, to have his bond revoked, and it was never granted to us. He's gone, and there's nothing we can do about that, but hopefully we can find him. The bond was going to go to him. We preferred that the bond money went to the victim's family, which it did, and it's sitting in the trust account for the 3 kids of that victim. I think what's important here, though, what you need to ask Mr. Zavaleta when he's answering the question of the B&D scandal, is what his role has been in the past 3 years, what he's done in the past 3 years. He has had that case because he's been a port commissioner for 3 years. In 2004, when he got elected, he didn't want the DA's office. He didn't want the federal government to look at it. When 2005 came about, they claimed that as an asset. Look at the Brownsville Herald. They claimed the $21 million as an asset. At the end of 2005, they actually said, you know what, it was only $9 million that was taken, and really out of the $9 million, I think only 1.7 of that was what we really needed to look at. He handpicked the attorneys that tried the civil case. The 2-year Mr. Gomez, and the other one, Mr. Willett, and he was given the authority to pick the attorney in Houston, which he did. Fast forward to 2006, during the litigation. He's no longer chairman. What happens? He doesn't show up for work anymore. He misses 9 meetings. Is that the type of DA you want? When it gets tough, when it gets hot, he's not going to show up for work? Is that what you want? That's what you'll get if you elect him. The additional thing is, he picked these attorneys himself. He knew what these attorneys could do. He knew what kind of evidence they had. So it's no surprise when they weren't able to produce anything. He didn't ask for my office to get involved until 2007. Look it up, it's in the Herald. In 2007, after the case was settled and they didn't get what they wanted, which was money, then he called me in to try to save the day. And now it's my fault because they can't do their job. I would think again. Take a look at that. And when you think about it, the biggest mistake he made, and the one you need to be worried about if he becomes DA, think about this. He's going to go out to the paper and tell the defendants what he's going to do. That's what he did with this case here. He told Dan and Bob, I'm going to sue you in a month if you don't give me the money back. And what happened? They beat him to the punch. You want him to go out there and tell those crooks, I'm going to come see you and get that marijuana if you don't get rid of it. That's what's going to happen. Think about that, ladies and gentlemen.
We'll move to Mr. Zavaleta's question, which is specific to him. And he's asked that you be given, including his answer, an equivalent rejoinder, which I think is 30 seconds should be adequate. So these are 4-minute answers. And the question to Mr. Zavaleta is, Brownsville Navigation District Commissioner Zavaleta, you have served almost 4 years on the B&D Board of Directors. 1 year of which you served as board president. During this period and before your election to the board, $17 to $21 million or more was spent for the permitting, design, and construction of a proposed international bridge to Mexico, none of which have to date been accomplished, that I'm aware of. Several questions. A, please explain what, in your perception, transpired in a short version, they have to be fairly short, of where you think the money went. B, where are we at this point in time and why? And C, what your involvement has been as a board member, Mr. Zellweger.
You elected me by a 61% margin in May of 2004 based on my promise to investigate what happened to the $21 million. And ladies and gentlemen, I've done that. I was true to my word. I validated your trust in me. We brought before you and put for public record on our website at the Port of Brownsville exactly what happened to this money. We hired by unanimous vote a very well-trained attorney named Charles Willett, who conducted an exhaustive investigation into how this money was paid, in some cases with invoices just saying for professional services rendered, $1 million received paid. We brought that evidence before you. Mr. Willett reported that of the $21 million spent, $15 million went to a company in Houston. They claimed that $9 million of that was spent in Mexico. In January of 2005, when Mr. Willett's report was finished, Mr. Villalobos had just taken office. Mr. Villalobos, contrary to what he just said today, became directly involved in this investigation because he subpoenaed Mr. Willett and his report in January of 2005, asking that his entire work product, we're talking boxes of documents, be turned over to the district attorney's office. Mr. Villalobos, if you'll remember, I called you up from my office to yours as chairman of the board, thanking you for your interest in the Brownsville Navigation District scandal and pledging to you my full and complete cooperation. Ladies and gentlemen, that was in January of 2005. In also February of 2005, 1 month later, assuming that the district attorney was continuing its work of investigating what crimes could be made out from the facts that Mr. Willett reported, we put on our agenda for public action an action item based on Mr. Willett's report. As a public entity, we have to take public action. We cannot secretly sue. We cannot decide in executive session that we want to file a lawsuit. That lawsuit, if filed based on an executive session decision, would be challenged under the Rules of Civil Procedure for lack of authority. And so Commissioner Gaiman and I put an item on the agenda asking that the board vote in accordance with Mr. Willett's recommendations. Before that item, before we actually discussed that item in early February of 2005, I asked my fellow commissioners in executive session for the authority, to give me the authority to act in conjunction with Mr. Willett to do whatever was necessary to protect the Brownsville Navigation District, including the immediate filing of suit. There were 5 commissioners on the board, including myself. I could only get Commissioner Gaiman to agree with that proposition. That proposition would not succeed if that item were taken to a vote. And so therefore, by this time, ladies and gentlemen, by the time we got to open session, I knew from my conversations with Commissioner Gaiman that I did not have 3 votes to file a lawsuit. And the last thing that I would do was bring an item to file a lawsuit and have that fail in a public vote. That would be demoralizing to the Brownsville Navigation District, and it would also weaken us from a negotiating standpoint if our adversary knew that we couldn't even carry a vote to sue them. The head count on February 4th of 2005 when this item came before the commissioners was I was in favor of suing, Commissioner Gaiman was in favor of suing, Commissioner De Los Santos was against suing, Commissioner Collins was against suing, Commissioner Cristiano was the swing vote. My calculation of Commissioner Cristiano and the calculation of Commissioner Gaiman of Mr. Cristiano was that he preferred not to sue. And rather than risk a 3-2 vote against suing, I went along with the suggestion that we try to mediate this case before bringing it to a lawsuit. Little did I know, ladies and gentlemen, that at that time, Commissioner Cristiano was having secret conversations with Dannenbaum Engineering. The famous "I am your friend" conversations. Ask me whatever you want and I will tell you. What was happening, ladies and gentlemen, was despite, or I guess without me knowing, all of our signals in the huddle were being transmitted to the other team. And they were reading our signals and knowing exactly where we were headed. That's why we didn't file a lawsuit in Cameron County, Mr. Villalobos. But you know what? I have done a lot more in 3 years on behalf of the taxpayers of Brownsville Navigation District, Mr. Villalobos, than you've done on behalf of the taxpayers of the Brownsville Navigation District. You've had this case. You could have called a grand jury as long ago as January of 2005. It is absolutely unconscionable to say after 2 years, I have 30 seconds left. Okay. It is absolutely unconscionable after 2 years of having Mr. Willette's report to say, I have not even a reason to call a grand jury. That is a failing of the job. Thank you.
And the next question is question 8, gentlemen, on page 1. Negative campaigning and attack ads. Both of you have been accused of employing these campaign methods. What is your response to this allegation, and do you remain an allegation? And do you intend to continue employing these methods? We'll start off with Mr. Zavaleta.
Well, first of all, ladies and gentlemen, I believe it is a negative ad to suggest that a candidate for the chief prosecutor office is a crook. And Mr. Villalobos ran an ad that did not tell you the whole story. Yes, I was indicted in 1988. Yes, Judge Hester, who everyone knows is very tough on criminals, dismissed the charge in open court after the complaining witness said that she was mistaken. I think it was a negative ad to suggest, as Mr. Villalobos did, that your choice for district attorney is under felony indictment. However, the ad that I ran, and by the way, that happened 20 years ago as well, the ad that I ran was based on Mr. Villalobos' official actions in office in letting a murderer go free. An action that just happened 9 months ago. An action that has placed this entire county at risk. An ad, by the way, that has yet to be refuted in any of its parts. That the district attorney failed to object. Go to our website, peter4da.com. We have the transcript of the proceeding. Judge Lemus is actually asking, where is Mr. Villalobos? Where is Mr. Madigan? They were nowhere to be found, ladies and gentlemen. They were missing in action. And when they did show, they did not object. They let a killer have a 60-day head start so that he could perhaps kill again. Is that a negative ad? Or is that giving you a reason to not return him to office for 4 years? I believe it's the latter. Thank you.
Every day in court, we have to deal with attacks. I'm used to attacks. They don't bother me. What bothers my opponent is that I'm a DA who fights back. I like to tell it how it is, and if you want to pick a fight with me, I'm going to pick a fight with you back. I think he's being untruthful. He was indicted, but as a prosecutor, and I've been a prosecutor now 3 as a DA, 4 as an assistant DA, as a defense attorney now for more than 10 years, I know how cases get dismissed. They don't get dismissed because they're mistakes. They don't get indicted because they're mistakes. Once you get indicted, it's beyond a mistake. When you get it dismissed, it's because the deal has been worked out. Anybody who's a lawyer knows that. As far as admit, I've explained that till I'm blue in the face, and I'll explain it again. The judge decides what happens to a defendant. It's a total misstatement to say that we allow him to go free. That's not what we do. You go and ask any lawyer, defense attorney or not, and they'll tell you our office has an impeccable reputation for that. We convict people and we put people away. I'm proud of that record. We're going to continue doing that. I'm asking this for 4 additional years. Thank you.
We are running over time at this point. We had a couple of other questions. We're not going to be able to get to them. So before we do the recap, I'd like to make a quick announcement. After we recess here, we'll have a short, say, 5-6 minute recess. We'll come back with the sheriff's candidates and we'll let us do the same thing again. But I'd like to make an announcement that On February 20th, same time, same place, Wednesday, February 20th, we're going to have District 37. We're going to have Representative Oliveira and his challenger, Mr. Shergold. They'll be first on the bill. And then we're going to have the Cameron County Precinct 1, Sophia Benavides, and challenger Lucina Rosenbaum will be here that night. So this last portion is the candidate recap, and we'll start with Mr. Villalobos for 10 minutes.
I think as voters and citizens, you have to decide what's important in your life. You have to decide if you want a DA that knows what he's doing in court, or if you want one who's going to be learning on the job. Think about the type of cases that we have. We have a triple homicide. We have the Rubio case that we have to retry. Completely retry that case from scratch. The most horrific crime that's occurred in our county. You want somebody that can go into court and know what he's saying, know what he's talking about, direct traffic in there with his attorneys, direct traffic with his investigators, make sure that the job gets done, or do you want to have somebody that goes in there and doesn't have an idea or a clue as to what to do next? And a person that's going to have to hire other people to do that work. And think about this, all of you that are in your professions, do you want a boss ahead of you that doesn't know how to do your job? Think about what that's going to create for morale in the office. How, if your job, if your boss who hires you, who doesn't know what you're doing, how is he going to know to even hire you? Think about that. This is about experience. This is about you wanting a DA that can go in there and get the job done. They can go to that crime scene and tell the officers what they need to do. They can go talk to DPS lab and say, this is what I need. They can go into a courtroom and explain that to a jury. This is not something that you sleep with some tapes and a headphone and you absorb it overnight. I don't go practice medical now. I never will. I practice criminal law. That's all I do. I'm good at it. And I think you should return me for 4 more years so I can continue doing it.
Ladies and gentlemen, I'm asking for your vote tonight to be your district attorney, and I promise you that I will lead by example and not by mere rhetoric. Time and time again, even though Mr. Villalobos says he wanted to be a hands-on lawyer, he has been missing in action. When a woman in Briarwick subdivision was accused of killing her husband while he slept at point-blank range in a 3-week-long trial, ladies and gentlemen, just 1 floor away from where Mr. Villalobos sits in his office, Mr. Villalobos never bothered to show up at all in that case. He didn't show up to examine a witness. He didn't show up to cross-examine a witness. He didn't show up to prepare an expert. He didn't show up even after the jury had convicted this woman and the jury was asked to impose a punishment. What more important job could our so-called hands-on district attorney have than show up in court on a first-degree murder case after a jury has convicted than to ask the ladies and gentlemen of the jury to send her to jail for life or for death? Mr. Villalobos did not think it was important enough to show up because he didn't. What was he doing, ladies and gentlemen? When Amit Livingston was being asked, when his attorneys were asking for a 60-day head start, why wasn't Mr. Villalobos present? Why was Judge Lemus asking for him on the record? It's very, very easy, ladies and gentlemen, to blame other people, as we've heard tonight. You know, it's the judge's fault. You know, it's the jury's fault. But yet, in his website, he takes credit for sentences that his office receives. So if he can take credit for stiff sentences, he must certainly be blamed for travesties in the sentencing process, as what happened to Tracy Rhodey and as what happened to Amit Livingston. I will be a hands-on district attorney. I will not only assemble a dedicated and talented team of professionals, I will work with them in the courtroom. We will have no limits, ladies and gentlemen. The district attorney's office are the good guys. I will